My Lord, you kind of indicated I could just review my notes over lunchtime, which I've done. Can I just really flag 3 points? I'll do it as quickly as I possibly can. I won't take any time over it. The first is that when I was dealing with my second issue, I told the court there were 2 reports I was going to go to. The first was the Royal College report. Can I just give the court the reference to the second? It's the Committee for Health report on the bill, and it's in Appendix, which is at tab 3, page 128 is where it starts, EF 207, and the relevant extracts are in fact set out in full at paragraph 10A of our written case, which is supplemental EF, page 62. So I don't make any submissions on that, you have the material there. The second point of the 3 was just one issue that I was about to come to just before the luncheon adjournment, was to say a very brief word about the criminality provision in the bill and the nature of the criminal penalty. And the submission is this: we accept, obviously, as we have to, that the bill does impose a criminal sanction for breach, but it is a minor one. And as to the significance of the severity of a criminal penalty, we pray in aid this court's decision in the Poor case. That's Authorities Bundle tab 3, volume 3, tab 30, EF 1327. That's the case about terrorism offences concerning the carrying of articles which raise a reasonable suspicion that the accused was a member of a prescribed organisation, so terrorist-related offending. In that case, the offence was triable summarily and carried a penalty of 6 months imprisonment. You can see that from paragraph 17 of the judgment.
Can I check I've got the right page number?
Yes.
I think you said 1327?
I did, my lord. I hope that's correct. Let me just...
In which bundle?
Bundle...
I mean the main electronic bundle or the supplementary?
The main one, and it's behind... That's right. It's the main one. Volume 3, tab 30. 1237. Right. I'm so sorry, my lord. 1237.
Yeah.
My mistake.
Which paragraph was it?
So paragraph 17 sets out the penalty at 6 months, and then paragraph 68 at 1257, the court finds that one of the primary reasons why the legislation, not the only one, but one of them, why the legislation struck a fair balance was because the criminal sanctions were comparatively minor. Now, what we say is compare that to the position with Clause 5, where there's no question at all of imprisonment. My Lord Reid asked yesterday whether the level 2 fine was £500, and it is, under the legislation currently applicable. I've already made the point that a number of other jurisdictions back this sort of legislation with a criminal sanction involving imprisonment. There's also the point, of course, that you will have seen made in the Assembly debates and elsewhere, well, what about other criminal sanctions that could be used instead? What we say about that is the use of a criminal sanction to prevent somebody in the first place from doing it, so for example through harassment or something like that, it is not very much use where it doesn't assist the woman in actually gaining access to the facilities in the first place. That's why you need the safe space. So prosecution for harassment may be difficult because you need a course of conduct, but it's of no comfort to a woman who can't access the facilities and is then abused for trying to do so. So we said that's a relevant consideration when you're looking at that part of the balance. And of course also this needs to be seen in the context of Clause 6, which provides a power for a constable to remove somebody from the area without necessarily moving to prosecution thereafter. So there is a gradated scheme of enforcement here. My lords, my ladies, that was my second point. The third and final point I wanted just to flag was simply to explain why it is you had 2 cases from us on your desks overnight. I apologise because one of those, in fact, was already in the bundles. That was our oversight. I apologise for that. There are cases of DS, which you were taken to by the Lord Advocate this morning, Lord Hope's speech at paragraph 24. The second case is the case of ANS. We rely there on paragraph 17 of my Lord Reid's judgment. It's about the proper approach to section 3 reading down in a devolution challenge such as this, and it cites the approach of Lord Hope in DS. You have those authorities there. That's what they're there for. My ladies, my lords, I'm extremely grateful for the extra time after lunch. Unless there are any further questions, those are my submissions on behalf of the Commission.
No, thank you very much indeed, Mr.
Grateful, my lord.
Ms. Nagrali.
My ladies, my lords, Justice is very grateful for the opportunity to intervene in this case. And we do so on what is, in essence, a point of statutory construction. That is that an express lawful or reasonable excuse clause is not a prerequisite for a criminal court to assess whether a conviction would constitute a proportionate restriction of a defendant's Article 9, 10 and 11 rights on the facts of a given case. It's a narrow point, but it is a very important one in circumstances where the Attorney General's case is that an express reasonable excuse clause allowing for a proportionality analysis at trial would, in Dr. McGlean's submission, be curative of the matters that have been raised by the Attorney General in relation to Clause 52A. Now, our submission is that there is no need for that cure. Pursuant to Section 6 of the Human Rights Act, a court, including a magistrates' court in Northern Ireland, may not act in a manner incompatible with Convention rights. It is unlawful for them to do so under Section 6.1 of the HRA. And that means that where Articles 9, 10 and 11 are engaged, absent clear statutory language to the contrary, a court cannot act to convict a defendant unless they're sure that a conviction would constitute a proportionate restriction of those rights. Now, that's not leaving things to the vagaries of litigation or relying on summary prosecutions to develop the law. It's a straightforward issue of legality, and proportionality is in that way baked into the clause, just like it can be baked in with an express lawful excuse clause. So that's my overarching submission. And in the short time that I have available to me, I'm going to focus my oral submissions on that issue and on two subsidiary issues. And they are that, first, as a matter of Strasbourg law, the general measures doctrine of animal defenders has no proper application in a criminal context in cases balancing qualified rights. The second is that lawful excuse clauses and reasonable excuse clauses are not synonymous with Article 9, 10 and 11 proportionality. It is perfectly possible for a criminal provision which does not include such a clause to be given effect in a manner compatible with Convention rights in an individual case, as indeed Dr. McGlean himself acknowledged in the case of Lee Brown when he was acting. Now, I'm necessarily going to take those points very quickly, so I don't propose to turn up documents unless strictly necessary. But before I turn to those three substantive submissions, a few just preliminary points. The first is that underlying Justice's intervention is the fact that numerous offences engaging Articles 9, 10 and 11 do not include express lawful excuse or reasonable excuse clauses. And just a sample of those are set out at paragraphs 46 to 49 and paragraph 55 of our written case, which begins at page 40 of the supplementary bundle behind tab 4. And many of those offences were enacted prior to the entry into force of the Human Rights Act, or indeed prior to the drafting of the Convention. And for this court to accept the Attorney General's arguments or to determine in general terms that the absence of an express lawful excuse obviates the need for a proportionality analysis at trial could impact very significantly on the protection of Article 9, 10 and 11 rights across Northern Ireland and indeed across Britain. The second preliminary point is that we do respectfully submit that Couturian was wrongly decided. As Dr. McGlean has highlighted, there are conflicting...
I'm sorry, I was distracted for a moment. Which case are you saying?
Couturian.
Couturian.
As Dr. McGlean highlighted, there are conflicting authorities on this, and I respectfully submit that the court should adopt the Scott O'Connelly and indeed Lee Brown line of authority rather than DPP and Couturian, which it didn't consider those authorities. And in my respectful submission, neither both DPP and Couturian were wrongly decided precisely because they didn't consider the relevant Strasbourg authorities. And it's not correct to say that Couturian is in effect settled law. It's being reconsidered by the court in the Attorney General's reference in relation to the Colston appeal. Matters in relation to, it is before the court again. Now, the third preliminary point that I want to raise, and I raised briefly, but it is important to do so given the exchanges this morning. Proportionality is, in my respectful submission, a matter of fact for the tribunal of fact. In a jury case, it is a matter for the jury. That was determined by this court in Ziegler, and the relevant paragraphs for that are paragraphs 59 and 60.
But not definitively. This is a larger court. We could overrule it.
Well, my lord, indeed, but there is simply insufficient time in the 30 minutes that I have to do justice to such an important proposition in a case that doesn't even raise questions about a jury trial. There is extensive authority that makes clear that it is a long-established principle in criminal law that defences involving value judgments are for the jury and cannot properly be withdrawn from the jury other than where they have no evidential basis. And that's Lord Justice Auld in Nicholson, Lord Justice Hughes in R&A, where he says the concept of reasonable excuse is par excellence a concept for decision by the jury on the individual facts of the case. There's Lord Widgery in Bellow, there's the Court of Appeal in Hammond, there's Lord Chief Justice Hughes, then Lord Chief Justice in R&A. And there's also the case of Brown, where again it was decided specifically in the context of the right to freedom of speech. There's the householder defences that have a proportionality element built into them. Now, I would respectfully submit that if the court does intend to determine this issue, that it does allow supplementary written interventions on the matter, because it is a matter of such significant importance. It would be important to have all of the relevant authorities before the court before making such a decision that would have such significance in future cases.
Because it would be possible to argue, would it not, that while the generality of cases looking at reasonable excuse, that may be correct, what you've just said, when within that one is looking at proportionality, one might say the proportionality decision is a matter of law, albeit it's got to be applied to the particular facts.
Well, my lord, this was discussed and was debated in Ziegler, and in my respectful submission, no, the answer is no, it's not a question of law, it is a question of facts. And the authorities do establish that in my respectful submission.
So you've sort of rattled through all those cases. They are mentioned in your...
My lady, they're not, because this issue wasn't raised other than in oral argument. It's not an issue that arises on the face of this case. Which
I see. So this issue being whether it's a question of law or fact rather than the role of the magistrate in...
Indeed, whether it's a question of law or fact, and whether it would then be for the tribunal of fact or for the tribunal of law. Obviously, the two combine in the magistrates' court, which is why I think it wasn't an issue in these proceedings. There are no distinct roles in that respect.
A related issue is whether statutory provisos dealing with reasonable excuse or lawful excuse are meant to address convention rights at all. You make the point that they can hardly... whether or not there is such a clause present can't be decisive. And I wonder whether it's even relevant. I mean, most of the statutes we deal with that have lawful excuse provisos or the like predate the Human Rights Act, and they would have been enacted with different considerations in mind.
My lord, precisely.
It may be a way through this is to treat proportionality as a separate issue. The alleged breach of a convention right, it's particularly easy it's to treat it as a distinct issue.
Well, my lord, yes, and the thrust of my submissions will be that it's not statutory provisions, it's not the elements of a crime that require a proportionality assessment, it is the engagement of the rights. Strasbourg has no consideration to the elements of a domestic crime in considering whether or not a proportionality analysis arises. It's simply, are the rights engaged? And if so, is the restriction on those rights proportionate? And in my respectful submission, that should be exactly the same position adopted by the domestic courts, as indeed it was adopted in Lee Brown. And if I can get to the mechanics of that, in response to the question by my Lloyd Jones, it's that exactly that. The requirement for a proportionality analysis at trial flows from Section 6 of the Human Rights Act, not from the elements of the offence. And that is because, as I said in my introduction, as a matter of domestic law, under Section 6.1, it is not open to a criminal court, including a magistrate's court, to act incompatibly with convention rights, other than in two circumstances. The first is Section 6.2a, where the court cannot act differently under the terms of primary legislation, and the second, which is Section 6.2b, where certain legal provisions cannot be read or given effect in a way which is compatible with convention rights. Now, neither of those categories apply in relation to this case, which concerns subordinate legislation. But even if they did, the cases of Lee, Brown, Scotto and Connolly show exactly how provisions not including a lawful excuse clause can be read and given effect in a way which is compatible with convention rights, and therefore must be so read in accordance with Section 2, so even where the exceptions apply. Now, certainly Parliament could legislate to rule out a proportionality analysis at trial in relation to a given crime to prevent the court itself doing a proportionality analysis. That's because Parliament is sovereign, it can do what it chooses. But the principle of legality explained by Lord Hoffman in Sims applies. And those principles are summarised at paragraph 55 of Bank Mellat. No need to turn it up, but it is at page 322 of the main authorities bundle. And the principle makes clear that fundamental rights cannot be taken away by generally or ambiguously expressed provisions of a statute. They can only be overridden through express words or necessary implication. So the mere absence of words, reasonable excuse, particularly, as my Lord says, in legal provisions drafted long before the Human Rights Act, is not sufficient to abrogate fundamental Article 9, 10, 11 rights, including the need for a fact-specific assessment at trial.
Do you apply that to all offences? So if I was to give you, the most heinous physical rape or assault occasioning actual bodily harm, do you apply the same argument whatever the type of offence?
My Lord, Articles 9, 10 and 11 have to be engaged, and there are, as my Lord will know, categories of acts to which Articles 9, 10 and 11 don't apply. So violence, incitement to violence, undermining the foundations of a democratic society. They're the three exclusionary categories, particularly in relation to Article 11. So insofar as it was determined that an act was violent, so for example, if that were a matter for the jury to consider, the jury considers that it is violent, they wouldn't need to then go on and consider the proportionality analysis.
What about criminal damage?
Well, in relation to criminal damage, there is a lawful excuse clause, and the lawful excuse clause means that Articles 10 and 11 are engaged. Not all acts of criminal damage. Criminal damage can involve walking on grass, it can involve a scratch to a barrier, it can involve many different things that are extremely trivial in nature and are capable of occurring routinely in the course of protests. There's no carve-out in Strasbourg jurisprudence for criminal damage from Articles 10 and 11. So that's the position in relation to Parliament. Parliament could legislate to preclude a proportionality analysis at trial, and that's contrary to the reasoning of Katchourian at paragraph 71. And that is worth turning up briefly. That's at... So the case starts at page 442, and paragraph 71 is at page 458. And the judgment says, we do not accept that Section 6 imposes a freestanding obligation on a court to be satisfied that a conviction would be a proportionate interference with convention rights if that is not an ingredient of a statutory offence. This suggestion would make it impossible for the legislature to enact a general measure which satisfactorily addresses proportionality itself to make case-by-case assessment unnecessary. It is well established that such measures are permissible, see Animal Defenders. Well, with respect, that's not correct. Parliament could act to take away fundamental rights. It just needs to say so clearly. But a general rule, as a general rule, that intention cannot reasonably or appropriately be inferred from the mere absence of a reasonable excuse clause.
But I think the Lord Advocate goes further. I think your submission would work for primary legislation, but I think the Lord Advocate goes further to say even if one reads this bill as mandating, requiring the Department of Health to list a clinic if it's notified by the operator of the premises, nonetheless, because this is subordinate legislation, the exercise has to be gone through again at the clinic stage and at the Department of Health stage.
Well, my lady, it certainly has to be gone through at the court stage in the sense, not the same analysis that the Assembly went through, but the court certainly has to undertake its own proportionality analysis on the facts, because of course there's a clear difference between the proportionality in general terms of a provision and the proportionality of its application in a general case, and that's the case of MM. In a particular case, yes.
So what would be the effect on this analysis of a decision by this court that the legislation is proportionate in the sense that 100 metres is proportionate? If we were to reject the attorney's arguments on, well, it could be done by a less intrusive measure, what would be the effect of a ruling of this court that it is compatible on those grounds rather than on the grounds put forward by the Lord Advocate on the exercise that would need to be carried out in the Magistrates' Court?
Well, my lady, again, I can only, by reference to the case of MM, I think that's so. As a general rule, the court can say this is proportionate. It's proportionate as a general rule. It's not disproportionate to have safety zones outside an abortion clinic. It's not even disproportionate to have safety zones 100 metres or even potentially up to 250 metres outside an abortion clinic. But the court needs to undertake that assessment on the particular facts of the given case. And my lady asked for some examples earlier, and just as a few examples that spring to mind. Somebody who undertakes a solitary kneeling protest 90 metres away from an abortion clinic at 7:30 a.m. in the morning, holding up a holy picture. Now, they may be reckless as to whether a doctor who was going to turn up early for work might see them, but a court, if faced with that kind of prosecution, a court might well apply a different proportionality analysis, or the proportionality analysis applied by a court at trial might be different in those circumstances to people who are accosting people coming in and outside of an abortion clinic. Similarly, and my lady will be much more familiar with the geography than me, but if one were to draw a 100-mile radius around the 100-metre radius around the abortion clinic on College Street, one would take in part of the front of Belfast City Hall. 250 metres would take in a Catholic chapel and the whole of Belfast City Hall. And so again, a court faced with somebody who's leafleting outside the Catholic Church or getting a petition signed outside Belfast City Hall might well treat that very differently, again, to people who are accosting people outside of an abortion clinic. And that's what the proportionality analysis at trial enables. It enables there to be this broad legislation, but it prevents people being prosecuted for what would, or being convicted for what would otherwise be, in a manner that would otherwise be disproportionate in relation to their Article 9, 10 and 11 rights.
So would this have to take place in every case?
Well, my lord, in some cases the analysis might be pretty swift, but in other cases it would be more detailed. But the Strasbourg case law says that there need to be sufficient reasons given in relation to any interference with Article 10 and 11 rights. So the court would at least have to make a determination on that at trial. Because, as I said, the court, as a public authority, cannot act in a manner incompatible with convention rights. So it cannot convict a defendant where that would constitute a disproportionate restriction of their rights. But it also can't turn a blind eye or delegate that responsibility to another public body or indeed to the legislature. And I won't, I'll ask the court to read it, but not at this moment, paragraph 69, where the court in Katurian gives another reason why it can't accept a general freestanding obligation under Section 6. And again, with respect, it is simply wrong. It seeks to carve out another exception from Section 6, which just isn't there on the face of the authorities and isn't supported by any authorities, and which suggests that a court doesn't have to be satisfied that it would be disproportionate. Well, a court does have to be satisfied, because otherwise it will itself be acting unlawfully. And the House of Lords case of AG reference number 2, again, no need to turn it up, it's at page 115 of the supplementary bundle, is instructive in that regard. And that concerned an Article 5 case rather than an Article 9, 10, 11 case concerning delay. And the relevant paragraphs are paragraph 30 per Lord Bingham and 35 per Lord Nichols of Birkenhead. And they underscore that courts exist to uphold the law. And it can never be proper for a court to act in a way which Section 6 declares to be unlawful, i.e. in breach of convention rights. And given that it would be unlawful, as I say, the court cannot rely on the assessment of another body. And there's one case that would be useful to turn up. It's at tab 64, page 646 of the supplementary bundle. I think that reference is wrong, so it's tab 64.
If the offence is statutory and there's no element of lawful excuse or reasonable excuse to worry about, if it's statutory, unless you can alter its meaning by using Section 3, the court just has to give effect to the statutory provision.
Well, my lord, the point is that it is possible to read it in a manner compatible with Articles 10 and 11, which was demonstrated in the case of Lee Brown. A court must act in accordance with Section 6.1 unless it cannot do otherwise. And the cases make clear that it is possible to interpret it in a manner compatible with Articles 10 and 11, and so it should. And this case may well be assistance. It's the case of Weyer. It's at page...
That's got nothing to do with this.
Well, my lord, it does, in the sense that it's a Proceeds of Crime Act case, and it is equivalent to here because the legislature, and here Parliament, had acted to remove the discretion from the Crown Court in the Proceeds of Crime Act. And nevertheless, and this is at page 646, what the court says, and this is at paragraph just above the letter B, Section 6 of the Human Rights Act imposes on prosecutors the duty not to act in a manner incompatible with convention rights. So the Crown has an important preliminary function in ensuring that a disproportionate order is not sought. But the safeguard of the defendant's convention rights under A1P1, not to be the object of a disproportionate order, does not and must not depend on prosecutorial discretion, nor on the limited jurisdiction of the High Court. Mr. Perry and Lord Pannick were correct to identify the repository of the control in the person of the Crown Court judge, subject to the review and jurisdiction of the Court of Appeal. And so we do say that is very relevant, because, as I said, that was a case where Parliament had legislated and reached a balance that Parliament considered to be appropriate. But nevertheless, in order to safeguard convention rights, the court effectively read into POCA a provision that it had to be given effect in a manner compliant with A1P1. And that foreshadows the judgment in Ziegler, where, again, no need to turn it up, the reference is paragraph 57, page 484, where the court said that the magistrates' court judge is a public authority and it is his assessment of proportionality of the interference that is relevant. And that is, with respect, why the court must itself be satisfied of the proportionality in a given case.
I recognise you're obviously short of time, but I was in Ware. Was that not to do with the exercise of a discretion by the court?
Well, my lord, certainly the way what the court says at paragraph 4 was that, and I can turn this up, it's at page 640, and 3 lines down paragraph 4, the 1995 Act removed from the Crown Court almost all discretion as to the making or quantum of a confiscation order.
Yeah. Yeah.
So, in fact, POCA had removed the discretion.
Well, almost all discretion. It was a specific provision that was that Ware was concerned with, to do with how the court responded to an application for a confiscation order.
Well, my lord, I don't labour the point.
I haven't looked at this for 10 years, but I'm just trying to understand what
my lord,
was talking about.
I don't labour the point. It's simply that the court makes the point that it's the court that is it is in the court that the protection of convention right rests. That's simply the point that I make. I won't labour it any further than that.
Can I just ask you, is your submission indicating that if we were to regard the bill here as convention compliant, that there would be very few cases where there would need to be a proportionality assessment, or are you saying in principle every single case could be susceptible to a proportionality analysis?
Well, my lord, like Section 137 of the Highways Act, or so many offences that have a lawful excuse clause, the answer would be yes. But that doesn't mean that it acts as a get-out-of-fine-free card for protesters. The courts will be undertaking the same balance at court between the Article 8 rights of women and the Article 10 rights of protesters.
Sorry.
So can I just follow that on? I mean, the difference is the Highways Act has not gone through an analysis as to whether it's convention compliant. We're at the stage now of doing that, but we won't look at that's not been an issue under the Highways Act. Once that's been done, once that exercise has been gone through, which is what presumably we're doing here, it would seem odd to me that you would then effectively treat the situation in exactly the same way as you would the Highways Act, where there's been no convention compliant analysis.
Well, my lord, the Section 137 Highways Act was before the court in Ziegler. They would have said if they considered it to be incompatible with Articles 10 and 11. The point is that a provision can be itself compatible with convention rights, but that doesn't mean that it will be proportionate in all of its applications. And that's really, it goes to the animal defenders case in Strasbourg, basically, which is what the High Court is relying on in Katchourian to say that it's well established that there are general measures where you don't have to take into account the facts. And it just simply isn't the case. In the animal defenders case concerned general measures that may apply to predefined situations regardless of the facts of the case. And the court said that was fine, even if it might result in hard cases. But hard cases in animal defenders meant that people might not have their advert played on the television. And I'm not seeking to minimise the restriction of Article 10 or 11 rights that would entail, but in a criminal context, a hard case means that someone would be convicted even though the conviction was a disproportionate interference with their convention rights. And that's necessarily wrong in my respectful submission. The criminal context is different to the regulatory context, as the authorities subsequent to animal defenders make clear, and those authorities were not before the court in Katchourian. And Dr. McGleenan referred to two of them yesterday. They are Perenchek and Hanziewski, and they make clear that there has to be a detailed factual assessment of the specific conduct and of the restriction with it in order for a restriction by way of a conviction to be proportionate. And that is even where it is just defined, as it was in Hanziewski. And in Perenchek, in a paragraph that Dr. McGleenan didn't refer to, the court specifically distinguished between the animal defenders case and a criminal context. Whilst Dr McLean did refer to the case of Pretty, which concerned a challenge to a blanket ban on assisted suicide, that's plainly completely different. It involved what is effectively an unqualified Article 2 right to life. And in any event, the court in that case did not find that criminal conviction was invariably justified. The applicant was challenging the existence of the criminal offence in abstract. But it's notable that Dr McLean hasn't been able to refer to Strasbourg authority where a conviction for breach of Articles 9, 10 and 11 was considered proportionate without an analysis of the facts. And Dr McLean's suggestion that the ECHR has somehow resiled from Perenchek in Hanziiski also has no merit, and the court will see that we handed up the case of Mukin in Russia last night. That deals with that point comprehensively. The relevant paragraphs were highlighted to the court. But there are also other cases. Al-Khina in Russia is one of those. That's at page 910 of the supplementary bundles, paragraph 228, where the court finds a breach because the domestic courts failed to adduce relevant and sufficient reasons. And exactly that language is the language replicated in the case of Lee Brown, which is, in my respectful submission, the appropriate approach to these kind of cases. But, my lords, what's clear from the Strasbourg case law is that whenever there's an interference with Articles 9, 10 and 11 by way of conviction, the Strasbourg court consistently holds that it's necessary to have a particular analysis on the facts. And that's not a radical proposition. What would be a radical proposition would be criminal courts convicting defendants for a proportionate exercise of their convention rights.
Well, it's a rather idealistic proposition. Being in the real world, whether the police think it worthwhile charging people, whether prosecutors think it worthwhile going through a trial for the sake of a £500 fine, if it involves all this exercise, may be doubtful, and it may, in reality, render legislation useless.
Well, my lord, that isn't the case with, I come back to section 137
that's
of the...
why the CACD in Brown and Kachurian is trying to find a way of avoiding the practical problems that Ziegler has given rise to.
Well, my lord, with respect, it's far from clear that Ziegler has given rise to practical problems. Certainly in the criminal cases that I've been involved in since Ziegler, there have been very limited practical problems. It's been possible to give clear directions to a jury. Magistrates' courts have been able to follow it with ease and with clarity. So in my respectful submission, there isn't evidence of Ziegler having given rise to practical problems on its face. And in any event, certainly section 137 of the Highway, since the Human Rights Act came into effect, magistrates' courts have been doing the exercise that was done in Ziegler, that indeed came to be challenged and came to be before the Supreme Court. And the Supreme Court effectively endorsed the analysis by the Magistrates' Court. There was no suggestion that the Magistrates' Court in that case had got it wrong, that it had been overly burdensome, that this was something that was burdening the criminal justice system, or that it was something that should be prevented.
But it was common ground there that the proportionality assessment should be done under the reasonable excuse defence. That wasn't an issue, was it?
Certainly, what was an issue was whether it was an issue that what the defendants had done did not amount to a reasonable excuse under Articles 10 and 11. That was certainly an issue, and indeed the Divisional Court, of course, held that there had been no, that they should have been convicted, and that was what was appealed to the Supreme Court, and the Supreme Court found that obstructive conduct, even deliberately obstructive conduct, was capable of affording, in effect, a defence in these kind of cases, because it would be disproportionate to convict somebody in circumstances where they were properly exercising their Article 10 and 11 rights. But the thrust of my submissions is simply that an express lawful excuse is not synonymous with proportionality. Dr. McLean's case is that lawful excuse here would be curative of the issues in this provision. Lee Brown makes clear that the correct approach is to have regard to the elements of the offence and then to consider whether or not it would constitute a disproportionate interference with Convention rights. That was the view of the Lady Chief Justice, Sir Declan Morgan, Lord Justice Tracy. That reflected the view of the High Court of England in Wales in Connolly, the view of the High Court of England in Wales in Scotto. And there are certainly cases where lawful excuse has been considered to import a proportionality exercise, and Ziegler is one of those. But if the court goes to the reasoning of Lord Justice Singh in the High Court, he also says the starting point is section 6.1. He uses lawful excuse as a tool then to bring in Convention rights, but that's just how it was possible to interpret the provision in that case. That doesn't mean that it is impossible to interpret provisions otherwise in other cases. And just to return in the couple of minutes that are available, if indeed they are, to James and DPP, on which Katurian relies, Mr. Justice Ousley's judgment didn't refer to a single Strasbourg case. It didn't refer to Connolly. The concurring judgment refers to one case, but respectfully misunderstands the broader ECHR context. And although De Haal was disavowed, the judgment at page 56, paragraph 56, page 370, makes clear that Blackstone's had considered De Haal to be the correct approach in applying the ECHR. James isn't compatible with ECHR jurisprudence. The Divisional Court in Ziegler rightly cautioned that it was to be understood in its proper context, and the Supreme Court in Ziegler didn't even give it any consideration in its judgment, neither in the majority judgment nor the minority judgment. And that is notwithstanding that it was both referred to and quoted at paragraphs 22 and 23 of the appellant's case in that case in which I was instructed. Now, it cannot properly be suggested that in what my submission is a flawed approach in James, to which the Supreme Court didn't even refer, underpins the entirety of its judgment. And in my respectful submission, Katurian is in error through focusing on the elements of the crime, which is precisely what was warned against by Lord Steyn in Gaydon Mendoza, that it was not a literalistic approach, wasn't appropriate in Convention cases. And for that reason, Justice respectfully submits that the lack of a reasonable excuse clause should be no bar on this bill becoming law.
You've got a note of them, I think.
Supplementary submissions.
Well, you offered to give us some supplementary submissions on evaluative authorities concerned with evaluative judgments.
Yes, indeed, my Lord.
We'd be willing to entertain those submissions. Obviously, it'd have to be circulated. And again, if you could let us have those within 14 days.
My Lord, might I ask the permission for the court for 21 days, just if that wouldn't
Yes.
inconvenience the court too much?
Yes,
Thank
very
you.
well.
So that is on the point about whether the proportionality
Yeah.
question is a fact of law, or is
Yeah.
a question of law fact.
Yeah.
Thank you.
Yes, Mr. McLean.
My Lord, my ladies, there is an issue arising about the role of this court, in this context, and we are here dealing with a reference by the Attorney General under the devolution statutes. Parliament has entrusted the court with a particular supervisory function over the devolved institutions with respect to their law-making powers, and against that background, we say wary of suggestions that the court should be adopting a self-denying approach or high thresholds, or in fact deferring these matters for further consideration by other courts. The Attorney General has referred this matter before the court, the quality and extent of the debate yesterday and today illustrates that these are proper issues for consideration by the court, and there would seem to be little merit in deferring the issue to be dealt with elsewhere. The value of the process under the Northern Ireland Act and the Scotland Act is that we bring the matter here for expeditious consideration. The attorney could, of course, refer it after it's had assent, or could refer it in the course of proceedings, or we could wait for litigation to arise. But arise it will, and we will be here, no doubt, in years to come. The time to address the issue is, we say, now. Against that background, we have heard considerable debate on an ab ante threshold to be applied in cases of this type. I would observe that there is one authority which I think hasn't been opened to the court yet, and that's the decision of the Supreme Court in the Welsh reference in 2015 on the asbestos diseases. You'll find that at page EF 1334. And the interesting thing about that case is it's another pre-assent reference. It raises legislative competence issues on the scope of powers in terms of the reserved accepted matters, but also on proportionality. So there's an A1P1 convention point in that case. And the Supreme Court, 1334. So this is a devolution issue referred by the Welsh law officer in respect of legislation on both scope of powers and convention compliance. The court did not refer at all to any need for a heightened threshold or to satisfy a high hurdle in order for the issue to be grappled with. The court dealt with the proportionality point, and the judgment of Lord Mance, it's a leading judgment, deals with the issue and concludes that the provisions in question would be outside competence on compatibility grounds, and didn't get into any of the analysis of the numbers of cases or the metric that should be applied in order to make such a finding. Now, the court also found, or primarily found, on the excess of powers point, not the convention point, but certainly the majority in the case was prepared to take that course. Interestingly, Lord Thomas and Lady Hale also concurred in respect of the convention compliance legislative competence issue, so they too would have found that the legislation breached the equivalent provision which we are relying on in this context. It's particularly interesting in the sense that that decision of the Supreme Court in 2015 was essentially contemporaneous with the Beebe decision, which is found at EF 1399. Beebe was heard before the asbestos reference. Judgment was given in the reference first. Beebe's judgment was given in November of that year, and Beebe is the source for the Christian Institute or Christian Advocate Institute issue in terms of the high hurdle threshold. So in the other significant example that we have in the Supreme Court of a pre-assent convention compatibility reference, Supreme Court applied no threshold. And Beebe, which is the source, was a case of a similar composition of the court decided similarly. Now, what we say about high hurdles and thresholds, we've developed a submission yesterday. Our submission is what the court's looking for is, as per McLaughlin, a legally significant number of cases where there is likely to be a compatibility problem arising from the application of this particular section. And it's interesting in the examples that were discussed this morning, I think there were 5 examples discussed. Each of those examples involve cases where the actus reus of the offence would readily be made out in every case, and a case brought forward for prosecution would find that the evidential test was met and the prosecution would proceed unless the prosecution service applied some public interest analysis, which in light of the terms of the statute, it's difficult to see how that could result in any other outcome than the prosecution proceeding. So those are all cases where Article 10 and 11 rights would be engaged, and they're all cases where difficulties would arise. Interestingly, the example when Lord Burroughs gave of the putative father, who essentially prevails upon his partner not to go through with the termination, is a scenario which would also engage Article 8 rights in that context. So it's not just 9, 10, 11. There may be a scenario where there are competing Article 8 rights in play. So,
Mr. McGlean, can you refer us to the specific passage in medical costs for asbestos diseases where the test is formulated?
the test isn't formulated, my Lord, is the point. There is no test applied.
Test at all.
No, they don't apply
They just go on to assess it.
yes, straight through. Yeah, there's no issue there.
It was a one-off provision, wasn't it, imposing a liability
On insurers.
insurance companies to contribute to the costs incurred by the health service in treating mesothelioma victims.
Yes, and it was an A1P1 challenge. So it's, again, slightly different, but we are searching for consistency. Those who advise and looking for the approach here, we see that in that context, no one had to satisfy a threshold condition.
Yes, but it's rather like the Scottish AXA case. There is a case which is where a measure was going to affect a particular category of bodies, insurance companies, in an identical way in every case, and you could determine the proportionality of that. Whereas BB or Christian Institute, or this case, it's going to be applied to a large number of individuals whose circumstances may differ.
Yes.
I'm not saying that's the reason why one can't form a view, but it's at any rate it's a different type of situation.
My Lord, I think our submission is we ought to be wary of erecting barriers to the court's consideration of a reference brought by a law officer. These are not adversarial proceedings brought by parties. The law officer has formed a view. I say the court has a role in superintending the devolution settlements. The law officers have a role to be vigilant, eternally vigilant, for possible erosions of rights, whether they are Article 8 rights or whether they're the wider rights. So for those reasons we say there is a reason to be cautious about these sorts of hurdles being erected.
There's also an important point perhaps to be made. I mean, the only example that struck me as having any substance is Lord Borough's example of the boyfriend who wants his girlfriend to keep the baby. But we've seen in the Strasbourg authorities that we were taken to, I think by yourself, that a measure may be proportionate despite the fact that it results in some hard cases.
Yes.
And we've got ample authority for that domestically as well. An example being the case about student grants. Offhand, I'm trying to remember I can't remember the name of it offhand. It's one where Lord Sumption and I dissented.
Tejere?
Yes, that's it. That's the case. Yeah.
Yes. So there will be, I accept that is an approach the Strasbourg Court has taken.
Yeah. And the fact that there may be the exceptional hard case isn't inconsistent with the proportionality of a uniform measure.
Well, caution on that point, we would say, because the court's looking at it through a particular paradigm of the hard cases that come to court. The Strasbourg Court also looks at the chilling effect of the legislation. If you have a low threshold criminal liability, it might give rise to some hard cases, but what it will equally do is dissuade many people from taking courses of action they might well have done. So we don't see the visible hard cases, but there is in fact a chilling effect on people influencing or assisting or engaging with others. And I should say, on that point, the Human Rights Commission have taken the court to what they say is the context of all of this, and that they've given some reference to the CEDAW report. It's not irrelevant here that the legislation that made provision for termination of pregnancy in Northern Ireland was not brought forward by the Northern Ireland Assembly. It was brought forward by an act of the Westminster Parliament, one of the three acts that allowed for the continuation of devolution without an executive. And as part of the deal, in respect of that, the statute is at tab 47, page 1742. You will see, in order to maintain this very peculiar arrangement of no executive, no assembly and devolution, Parliament enacted legislation, and as part of a private member's amendment, the provisions were brought in terms of respect of termination of pregnancy. So it is still politically contentious in Northern Ireland.
There are problems about its implementation, haven't there?
Yes, it is politically contentious, but this goes to the question of whether or not there are other values in play in closing down scope for protest and debate. It's not simply the case that this is a settled position, democratically endorsed in every way. It is and has been an issue of some controversy, and it's important to allow for some scope for ventilation of peaceful objections to that. And the attorney's concern is that 5.2a goes too far. 5.2b and c capture the graphic examples in large part that the Commission have opened to the Court. We don't say that reasonable excuse is the only curative. There are other ways in which the legislation could be addressed in order to make it proportionate. For example, the Human Rights Commission, in its own evidence to the Health Committee, and you have this in the bundle at page 237, contended for temporal limits. Their view was there were problems with the legislation as proposed, and there was a need for some temporal constraint. Now, that hasn't been enacted.
When you say temporal constraint, do you mean that the zone only operates certain hours of the day, or that it only operates for a year? Or?
Well, there is no end point. I suggest that it could be done both ways. There could be temporal limits insofar as the zone is operative during the clinic opening hours or during working days, or it could be temporal limits on the basis that it expires after 6 months. None of those features were put in place, and certainly the Human Rights Commission were arguing for them whenever the matter was before the Health Committee. So it's not the case that the only palliative is reasonable excuse. Reasonable excuse is one means of dealing with it, but not the only means. If the Court reflects for a moment on the contention about what would happen if we say the solution to all of this is proportionality balancing by the other public authorities, reflect for a moment on what's involved in a safe access zone. There are a number of actors. There's the operator, who may well not be a public authority. There's the health trust, who will own the facility. They may have to make a judgment on the proportionality contention. There's the department, who will have to make a proportionality judgment on whether they maintain the list. There's the police officers, who decide whether or not they take action by way of arrest. There's the PPS, who have to decide whether or not to bring a prosecution, applying the public interest test. And then there's the court. 5 or 6 layers of proportionality judgment on the cases that my learned friends are making would have to be made, each one of those being a challengeable public law decision. In our submission, one sees in Kerkurian the Lord Chief Justice striving to achieve workable solutions. What's suggested here by way of a proportionality ex post facto or ex after the fact assessment is a recipe for paralysis. It will be a situation resulting in endless litigation. And one of the reasons the attorney brings this forward, the attorney is not seeking the failure of the bill. The attorney is recognising the need for protection for the Article 8 rights of women, and a viable bill, a sustainable bill, is one that does not have an attritional battleground for public law complaints built in. And we say that's what arises in this context. So the answer is not, we say, to have the proportionality exercise on a rolling basis thereafter, for those pragmatic and practical reasons. It's also, we say, not the answer for doctrinal reasons, because you only get into an application of the proportionality analysis if you use Section 3 to read that mechanism into the statutory scheme. And how do we read that mechanism into a statutory scheme which is absolute in its terms? No scope for reasonable excuse, mandatory obligation on the department. The reading in would confound the well-settled Guyton-Godin-Mendoza approach, because it would involve going against the grain of the legislation. It's not what the Assembly intended. That's the difficulty with it. So we say that's not a solution for pragmatic, but also for principled reasons. It's also, in our submission, something that abrades with the settled line of authority in Kerkurian. We're having now something of a proxy appeal on that point. The attorney didn't bring the reference to have that outcome, but it may be that's an issue the court has to grapple with. But that line of authority stretches back. It is reasoned and well thought out by a divisional court that has looked at it systemically and determined that this is a viable means of operating the criminal justice system with offences of this nature. Set against that is a line of authority starting with the decision in DPP and Connolly. I'm not going to open it, but if the court looks to that, you will see it's a case where Lord Dyson essentially was looking at the Section 3 mechanism and reflecting on what it could do, perhaps too expansively, if you look back at it. The next case that applies it is a case called Scottow and DPP. It's a 2020 decision, nothing in between, and it simply adopts the same approach. So there's nothing like the same systemic analysis in the competing line of authority. All we say on behalf of the attorney is there are two lines of authority. The one which appears to us to give the most coherent reading to the application of these criminal offences is the one that results in the Couturian decision, and the court can take that course.
So you say Couturian was right, and because of that, if this bill is to be made compatible on the basis that there shouldn't be these 5 or 6 opportunities for review, then the best result would be for this court to say this bill is not compatible as it stands, but it would be if it had an express reasonable excuse defence. Is that where you get to?
That's an optimal outcome, we say. An optimal outcome reflecting the balance of rights that's actually in play in this debate. Because a number of the other options here, including the option that's suggested by the Lord Advocate, which is that the departments decide not to have a zone. Deciding not to have a zone, how does that assist the Article 8 rights of the service users who have to go? What that means is you actually erode the entire content of the bill in terms of achieving Article 8 protection. Those are not solutions which we say recommend themselves. But what we ask the Supreme Court to do, of course, is make a judgment on competence. What happens after that is for the Legislative Assembly, if it constitutes itself, to grapple with.
It's ultimately a reconsideration you're asking for, is that right?
It goes back to reconsideration stage. Now, there will be a need to look at Assembly standing orders, suspend them because we've come to the end of a mandate and there's a new mandate. But there is a mechanism with political will where the bill goes back with the view of the court and the Assembly takes the next step that it considers.
To an Assembly that is sitting?
Yes. None of us can control that. All of us wish for it, but if that Assembly is sitting, the consequence of a ruling on competence of the nature that I'm arguing for is that the democratic process picks up where it left off and judgments are made properly informed. And when one reflects back, I took you through the history of the bill, you can see very limited analysis, proper analysis of the convention balance in the debates, and actually very little advice given, and none from the law officer that was directed to this issue formally. So the Assembly would have the benefit of the court's consideration of the issue, and that's exactly what Parliament intended when it put the Section 11 power in the Northern Ireland Act. This is the constitutional arrangement functioning as it should, and functioning as it should in a context where it will actually enhance rights protection for the vulnerable women and also for those who have a legitimate right, we say, to protest.
Can I also ask you, Mr. McGlynn, something I had forgotten to ask you? Had the Attorney General thought about the nature of a reasonable excuse in these types of cases, and does that coincide with the discussion we've been having about potentially disproportionate convictions?
The Attorney General had no formal role in advising on the legislation in this case.
No, I mean in the context of this.
Of this?
Yeah.
Yes. I mean, it is the reason why we've referred the 5.2a question is partly because the amendment number 4 could have addressed the issue. Now, there's a difficulty with amendment number 4 in a sense, in that it would then still require a proportionality balance to be carried out by the court, but that would be, again, the will of the legislature, not an uncontrolled arrangement in terms of proportionality assessment. So that is a possible means of dealing with. There are other ways of dealing with the proportionality imbalance. The concept of indirect influence is a concept which the court might think is too elastic or too ill-defined to form a proper basis for criminal liability. So there are elements to the offence which could also be adjusted, or the temporal point which Lady Rose has raised with me. The issue of next steps, of course, a matter that will require developments politically. But there is, we say, a proper question before the court. The court shouldn't erect hurdles and thresholds to it, and the answer, we say, suggests itself in terms of the overall analysis. On the question of sight and sound, Lord Reid has raised the Australian authority, which touches on that issue. Now, I'll make a simple point about that authority vis-à-vis the Convention authorities, which speak to sight and sound. Under Section 2 of the Human Rights Act, this court's obliged to give effect and have regard to the Convention jurisprudence. It doesn't have the same obligation in respect of common law jurisdiction decisions, no matter how well considered and reasoned they are. But the short point on sight and sound is that the Supreme Court in Ziegler, and there's been some implicit criticism of it today, the Supreme Court in Ziegler endorsed and emphasised the sight and sound consideration. It actually quotes the Lash-Mankin provision, and clearly the Supreme Court in Ziegler considered that the right to protest within sight and sound was an inherent part of the Article 11 right, and its judgment appears to have been an endorsement of that position. So while there is Commonwealth authority which takes a slightly different view, our Supreme Court has adopted and endorsed the sight and sound concept in Lash-Mankin, and we say that line of reasoning should carry greater weight than the observations of the Australian courts. I also say, of course, we don't know, and one of the difficulties of looking at cases from the Commonwealth jurisdictions, we can only see from the report. We don't have a full knowledge of how that statute actually works. In this case, we're saying the court should look to Section 5.2a, but we're also saying it has to be read in its context. We need to see the entirety of the bill. How does it work? What are the temporal limits? Who reviews? Who makes the decisions? It's, we say, potentially difficult to make an assessment on Australian statutes when we don't have a full understanding of how they're meant to operate. So,
well, I think I can probably get a better grasp of the Australian statute than I can of the laws governing protests in Russia.
Well, indeed, my Lord, I understand that. But the obligations on you are clearly more sharply defined in respect to the Russian statute. Indeed, my Lords, I think I've addressed the points I need to address in my reply. Unless the court has questions, I'm grateful for the courtesy which the court listened to the reference.
That's very helpful. Thank you very much, Mr. McLean. Well, we're very grateful for the submissions we've received, and our gratitude extends to not only to those in the front row, but also to those sitting behind them, who will have contributed a great deal, I'm sure. We're conscious that there is a bill which has been passed and only awaits our judgment either to be reconsidered or to go forward for royal assent. So we will deal with this as quickly as we can. That said, we've allowed you some weeks to put in additional material, and there will be some disruption of our normal ways of working because of the fact that we're in the long vacation in just over a week's time. So I wouldn't realistically expect a judgment before the autumn, but we'll produce it as quickly as we can. Court will adjourn.